This is a short overview of employment law. This is based on common law agency with the idea of principal, agent. You can think of that employer, worker. It's employment law is modified and preempted by statutes and regulations. So I do want to distinguish employment law from labor law. Labor law deals with labor unions, in particular federal statutes, the National Labor Relations Act, the National Labor Relations Board. So I'm not going to talk about labor law, but it is distinguished from employment law. So with employment law, the presumption is that a person is employed at will. The exceptions being if there's a contract, as we said, you can have an oral or written contract, best to have a written one. If there's some sort of wrongful discharge, or this is a type of tort where, like a whistleblower or something similar to violation of public policy or statute, discrimination, etc. Let's talk about wages, hours, leaves. Federal law applies to certain industries and employers, typically with 50 or more employees. State goes lower. State of Washington's down to, I think, 15 or 8. And then below that, you still have agency law that's relevant. But there's a multi-layer layers of employment law. But as I said, federal law sets a floor. The states can give more benefits. So we have child labor laws, minimum wage laws. That's under the federal law. This is Fair Labor Standards Act, talks about for employees, they're entitled to minimum wage and overtime. There are such things as exempt employees who do certain activities, duties like executive, administrative, and get paid a minimum wage. So there's two tests, but they're still employees. So non-exempt, you're entitled to hourly and overtime. And I mentioned exempt employees. These are white collar exemptions. They would get paid a salary that has to meet a minimum threshold. The state of Washington has moved that up considerably. It's almost 60K. You have to perform legitimately executive, administrative, professional, or outside sales activities. Typical exempt employees and managers, executive professionals, but they do have to meet the salary and the duties tests. There's a huge incentive for employers to misclassify workers as exempt when they're not, or independent contractors as or to misclassify employees as independent contractors as a risk there, with liability for failure to pay statutory benefits, including minimum wage and overtime. I'll just briefly reference Family Medical Leave Act. Gives you 12 weeks of unpaid leave. On the federal level, states, including the state of Washington, has made that a paid leave deal. And the way that works is you don't have to take the 12 weeks in one continuum. You can take a few weeks at a time, but it's got to be for one of the legitimate reasons set forth in the statute, like a new birth, adoption, a serious medical condition for a loved one, etc. But important to know that. All right, health and safety, I mentioned this before, goes back to agency law, where the principal owes a duty to the agent or the worker to provide safe working conditions. This is codified in federal law by Occupational Safety Health Act, but other federal laws. And in the state of Washington, we have the main one is Washington Industrial Safety Health Act. A word about workers' comp. That's one of the benefits employees are entitled to if they are, separated or injured, I should say, if they're injured on the job. The big deal is, was it a on-the-job injury? Various benefits under the topic of income security, where employers have to pay and take out Social Security, Medicare, any health plan, COBRA's continuation of a health plan for up to 180 days. Normally that's better than the Affordable Care Act, but the Affordable Care Act is there as well. Retirement plans, unemployment comp is the idea that you are unemployed through no fault of your own, and you didn't engage in any gross misconduct, so you're entitled to unemployment compensation. All right, so immigration law, I'm not going to spend a lot of time on that, other than it's a cluster. Yeah, federal law, the main one is Immigration Reform and Control Act, which requires employers to verify the status of employees or face a stiff fine. So that's the I-9 verification form. You may have heard of that. All right, so let me talk about employment discrimination a bit. Size matters. As I said, federal covers employers with 15 or more. I misspoke when I said 50. State covers smaller employers, 8 and more. And it says common law agency rules still apply, like safe working conditions. Protected classes, everyone is in one. Race, color, national origin, religion, sex, including pregnancy, sexual orientation, gender identity, age, that's 40 or more. Disability, that can be physical, mental, or being perceived as having a disability. Genetic information as well. You can't be discriminated for that. Two basic types of discrimination are desperate treatment, where you're intentionally being treated differently based on your class, your protected class, your age, race, sex, color, whatever. Disparate impact is a neutral policy which disproportionately impacts a class of a protected class. This disparate impact is not as user-friendly under the current administration, but it has historically been a way to prove discrimination. Let me just say a couple words about harassment. That can be based on any protected class. So you have quid pro quo. This is a typical sexual harassment, like Harvey Weinstein. You do certain sexual favors and I'll give you a raise or something like that. Hostile environment is the more common, and this can again apply to any protected class situation, but it has to be something that is a reasonable person wouldn't put up with it. Again, you look at the objective theory. So casual or isolated action normally is not enough, but can be depending on the severity. All right, so, and one of the big problems employers have is retaliation. You cannot retaliate against someone who makes even a allegation that ends up not to be true. Defenses, okay, a bunch of them. Business necessity, you, let's say, operate a business where people need to speak French or whatever, that's okay. Bona fide occupational qualification. Back in the day, an example would be in a women's clothing store, you could have specify that only women work there. Seniority systems, that allows for discrimination with people that are late coming in. This is a good one. After acquired evidence of employee misconduct. So if you're an employer and an employee sues you for discrimination, you can go back to the file, and if they lied to get the job, they're out. This is another interesting defense, the Alworth-Farragut. This is where the employer has a policy or germane to sexual harassment in particular. The employee who's claiming sexual harassment didn't follow it. That's why employers have these policies and training. And the argument there is essentially that the aggrieved employee failed to exhaust his or her administrative remedies. So that's employment law in a nutshell.